Okay, well, good afternoon, and welcome to the last in this semester of speakers. We're looking forward, of course, to a good lineup of speakers next semester as well, and we'll be circulating details around about that, and some of you have seen some of the upcoming speakers. But today we have a tremendous speaker with us, and Robert Leckey comes from McGill University, where he teaches constitutional law and family law, and works in his research in these fields as well as in comparative law. He's previously served as a law clerk to Justice Bastarache at the Supreme Court of Canada. He completed his doctoral studies in law at the University of Toronto as a Trudeau Scholar. His dissertation he's published under the title Contextual Subjects, Family, State and Relational Theory with the University of Toronto Press in 2008. He worked as a visiting scholar at the Université de Montréal at their Centre de Recherche en Éthique, and he joined the Faculty of Law at McGill University in July 2006. He's had a chillier welcome to Saskatchewan this time than the last time he was last here, I guess, for Congress in 2007. And we're delighted to have him back, even if the weather hasn't been as welcoming. I hope that you'll be welcoming and offer warm comments and questions. But he's going to speak on the topic of two mothers in fact and law, or two mothers in law and fact, I think a very interesting presentation awaits us. So with no further ado, I'll welcome Professor Leckey.
Are you hearing me through the microphone? Is it on a little bit? I'm used to one that goes around my head in a kind of distracting way, so it's always in the peripheral vision, but this is very nice. Thank you so much, and I'm very pleased to be here. And I'll be honest, I mean, Dwight alluded to the weather, but when he emailed me in mid-July and invited me to come back to Saskatoon, I really wasn't picturing ice sort of floating down the river and snowy fields, but it's great to be here. I thought before I dove right into the material that's in the paper, I thought I would just take a moment to sort of situate what I'm talking about in the larger context of some research I've done. So I've written several papers that address how legal systems have changed in response to the social fact of family practices by gay men and lesbians. And if we can think that family law generally is an exciting area for a number of reasons, the sort of mix of moral questions, what do we owe one another, with legal technical ones, the intersection of public and private law, human rights and private duties, the effects of gender, the difficulties of balancing freedom and autonomy against protection of vulnerable people, the fact that it's an area of law with very real effects on people's lives. If we think that all those things probably can be found in most areas of family law, it seems to me that legal responses to gay and lesbian families are particularly rich. And there's been so much change in recent years that I think there's an opportunity to see what can we learn about the legal system, what can we learn from how law works from looking in more detail at some of these changes. And I've done some work on the recognition of adult couples, and including its connections between charter litigation and private law. But at a kind of legal design level, it seems to me that the question of recognizing parenting is actually much more complicated. It's less of a sense of do we recognize, don't we recognize. There are all kinds of questions. If one wishes to recognize parenting by people in same-sex couples, how exactly does one do so? And so in some work that's extended over several years with funding by SSHRC, I've taken reforms that were enacted in the province of Quebec in 2002 as a point of departure and taken them in a number of different directions. And the Quebec rules that I'll be talking about today make special provision for female couples to be recognized as a child's legal parents. It happens that Quebec law has a legislated statement that surrogacy agreements violate public policy. So there's not gender parity on that front, and my work to date has focused more on the female side. And of course, the design challenge is how do you reconcile assisted procreation by female couples with the traditional framework of family law, which tends to drive towards recognizing fathers. So that's a sort of background piece. And a little more particularly, I did one paper a couple of years ago that contrasted laws changing to recognize female couples in two different institutional sites. So a couple of years ago, I contrasted legislative reforms passed in Quebec City in 2002 with a couple of judicial developments in the province of Ontario, in which charter claims were brought forward saying, look, the Vital Statistics Act regime needs to be changed to allow two women to register. And in that earlier paper, I said, look, we can see legislative reform in Quebec, judicial reform in Ontario. This is a sort of classic example of how the civil law changes and how the common law changes. And I still stand behind what I said in that paper, but I have rethought to an extent. I've realized that the Quebec example itself is more complicated, that there are more currents of change circulating within Quebec than I had acknowledged at that earlier time. And so the talk for today and the paper it's based on is a little bit about some of that richness and internal complexity within the legal system of Quebec's change. It's about the way in which legislative recognition of parenting by lesbian couples by Quebec's legislature hasn't actually marked the end of the road of their coming into view, if you will, within that province's family law. And the presentation is also about the politics of this story, particularly from the perspective of people concerned with law's historical failure to recognize multiple forms of family. So one might think of a perspective grounded in feminist theory or queer theory or gay and lesbian legal studies. And there are two major arguments that I'll share with you in the time this afternoon. The first I call the comparative law argument. So I'll be talking in a little more detail shortly about two judgments from the Quebec Court of Appeal in which they recognized the fact of lesbian mothering in circumstances where the legislative reforms were not actually engaged. And at first blush, these examples really seem to be something kind of foreign in the legal tradition of Quebec. But I suggest in the paper that it's possible to reconcile these with the civil law's view of the family and of family regulation. And I set out in the paper the idea that equality-seeking scholars actually should take very seriously the need to develop accounts of Quebec civil law that make space for such organic internal changes. That's a comparative law argument, and I won't be spending too long on it today. The second major argument for the talk I call the political argument, and it's this. From a justice-seeking perspective, the cases I'm going to talk about today are politically tricky in a way they might not appear at first. And I want to throw out the idea, and I hope we can discuss it, that where sort of progressive legislative reform has occurred, where a legislature has taken steps to recognize forms of family that were historically ignored, there can be a risk later on if judges continue to see themselves as having a sort of broad discretion to keep recognizing new kinds of family. And I'm going to talk about the example of known sperm donors and raise the question whether there are limits on the kinds of things judges should do. In other words, you might say one of the key questions for today is what kinds of discretionary moves by judges cease to be appropriate once a legislature has taken steps to recognize forms of family. I want to acknowledge, in places where a family law regime hasn't changed to reflect changing social practices, where sort of large areas of social life are shut out, as it were, it's perfectly understandable that people, as a strategic matter, would turn to the courts. It's perfectly understandable that people would frame a claim in functional terms or care terms, or say, factually, my family acts just like families recognized by family law. But where there are legislative means to provide legal recognition, there might be limits on the extent to which judges should be sort of expanding the boundaries of family recognition. So we have the comparative law argument, we have the political argument, and here's how I propose to lay them out for you in the time this afternoon. The first thing I'll do will be to provide a very brief overview of the traditional theory or traditional view of the civil law of the family in Quebec. The second thing will also be brief. I'll just give a little nutshell account of the 2002 reforms that are the base of this research project. The third will be to introduce in a little bit of detail the two Court of Appeal judgments that I think are so striking. These two judgments in which the Quebec Court of Appeal ordered shared custody in circumstances where a child had one legal parent and that parent had a former partner. And then we'll look at the comparative law argument that these decisions are civilian decisions and that progressive scholars should care about that characterization. And last, the political argument that these decisions are also a little bit unsettling and that they prompt serious reflection on the boundaries of judicial redefinition of family. Now, at the outset, nobody has sort of jumped up to pose this objection, but I'm just going to anticipate that you might ask, am I making a lot out of two Court of Appeal judgments? And this has occurred to me as I've thought about these ideas. But it seems to me two judgments sharing custody when a lesbian couple has broken up and the second woman has no legal tie to the child, two judgments in the last 3 years actually seems like quite a lot. And Quebec civil law cases rarely reach the Supreme Court of Canada. So practically speaking, the Quebec Court of Appeal is the final word in this area of law. So I think it's actually, I mean, it's not a large sample set, but I don't think it's a negligible one. And so I think it is worth trying to think through the implications of these judgments a little more carefully. Now, on the plane yesterday, as I was looking down at the snowy fields, it occurred to me you might not be coming today because you've already been thinking deeply about Quebec civil law and its approach to family. So I thought, just in case it's helpful, I thought I would just frame at the outset 3 levels of inquiry that I think we can see in the talk for today. I would be happy to hear your views on these 3 levels or anything else in the discussion time at the end. It seems to me the 3 levels we can see are substantive family law policy, what we might call, to be a little grand, legal theory and regulatory theory, and third, the role of legal scholars. And let me just tell you briefly why I see some, or the questions I see in those. On the substantive policy side, this topic raises the question, how easily should a legislature provide the means for a child to have a single parent, for someone to conceive and give birth to a child and be that child's only legal parent? It raises the question, should there be recognition of more than 2 parents, and if so, how and on what terms? So those are substantive family policy questions. On the legal or regulatory theory level, we could say, what is the right balance between formalism and functionalism in family regulation? And by formalism, I mean the idea that family law would have a sort of big division down the middle of it with a sharp divide between people characterized as being family members and people characterized as legal strangers. So a formal approach, it all turns on whether you have family status or not. And if you do have family status, a package of rights and obligations attaches to you, and if you don't, there's really very little standing or legal recognition. And Saskatchewan, of course, as I understand it, has a relatively functional approach. So you're to my knowledge, one of the 2 Canadian provinces to enfold unmarried couples in your matrimonial property regime, heavily functional. This is sort of saying if it quacks like a duck, let's regulate it like a duck. And that's a sharp contrast with Quebec, where unmarried couples are virtually invisible in family law. So the question, the sort of regulatory theory question, is where legislatures recognize formal means or provide formal means of family recognition, does the appropriate or legitimate role for functional regulation shrink a little bit? Another way you could ask the question, what kind of negative space should there be around someone's decision not to use certain legal means that are now available to him or her? On the adult couple front, before there was an option to marry, for example, people advanced functional claims. Once there is an option for same-sex couples to marry, what, if anything, should flow from the deliberate decision not to marry? And in the Quebec context, I'll raise the question where it's possible for a birth mother to have her partner recognized as another parent of the child. What, if any, legal weight should attach to the fact that someone may choose not to use those means in a fully informed way? We can think of other private law examples. What are the effects where parties think about concluding a contract and decide not to? And we know that there's still some scope for unjust enrichment and still some scope for promissory estoppel, but we still have some sense that the decision not to conclude a contract means something. Now, a clear difference between contract law and family law is the idea of children's best interests, and that clearly comes into the mix. But it is worth asking, what are the limits of judicial discretion where people know the legal options and choose not to take them up? And last, I mentioned the role of legal scholarship was another level of questions, simply to pose the question, how appropriate or helpful is it to raise critical concerns about an otherwise positive legal change? Because this paper, in a sense, suggests there are causes for worry in developments that so far seem to be basically pretty good in my view. And so is it better to sort of keep these little worries to oneself at home, or is it appropriate to sort of raise them and say, well, let's talk about these. How do we respond to these possible risks down the road? And there are differing points of view, I would think, within groups of feminists, within groups of gay and lesbian commentators on some of the issues in the paper. And to me, some of the most interesting questions in law are where people who share a broad political vision find themselves disagreeing on how to carry it out. And so that, I hope we can talk about that in the discussion period. Okay, so the first thing I promised was a little nutshell account of the traditional view of the civil law in Quebec. So Quebec private law is derived from France. It has a strongly substantive view of rights and duties. The person is the central legal idea. And another key feature of Quebec civil law, as of the civil law in many jurisdictions, is that it's written down. There's a civil code. The legislature has purported to exhaustively set out in writing all the key concepts of private law, all the basic rights and duties, all the relationships that individuals have towards one another and that individuals have towards property. And in this part of the paper, I emphasize two features. One is the idea that the legislature has a very privileged role as law reformer. There's much less of a sense that judges are constantly keeping the common law up to date in a civil law jurisdiction. The legislature is the key driver of law reform. And the second key feature to get your grasp of Quebec civil law filled in for today's purposes is that Quebec family law regulates through formal means, through having formal status and a sharp distinction between family members and legal strangers. Now, civil code presumes itself to be a definitionally exhaustive synthesis. The basic idea is that all the vocabulary for making legal argument is laid out in the code. And there's lots of disagreement. It's not a mechanical thing, but there's a sense that the code is gapless, that it sort of says, these are the resources of our legal system. It sets out all the key concepts. And then this formal family regulation I mentioned, it proceeds in the civil law through foundational institutions. There's marriage, and there's their term for parentage is filiation, and these are the core ideas. So adult couples are not recognized by law except to the extent that they formalize their relationship in a marriage. There's no duty of support, for example, between unmarried adult partners. And on the children front, filiation or legal parentage is the sole source of rights and duties. So once parental status is conferred and recognized, a set package of rights and duties follows, but there's no legislated avenue under Quebec law, for example, to recognize someone's step-parent. The fact someone's acted as a parent towards a child, the fact someone has stood in the place of a parent, and language familiar to some people in the room, perhaps from the Divorce Act or from other provincial regimes, has no place in Quebec law. So those are the key ideas. The legislature is the driver, and the means are very formal. And there seems to be considerable comfort with large swaths of social life just not being recognized by the regime on the family. The little wild card is that the front of the Civil Code also has some sort of mention that children's best interests are a key factor in decisions about them. So that's a little overview of Quebec civil law. And let me tell you briefly about the reforms that were passed in 2002 to provide a legal mechanism to recognize a child's two mothers when the child is born through assisted procreation. This example, in a sense, really shows us that formal family regulation doesn't need to be conservative. I think people in some of the common law provinces tend to bundle together sort of progress and adaptability and flexibility with functional regulation, with regulating things based on how they function and operate. But Quebec shows you can stick to formal status and still change. So Quebec civil law has not refused to change, but when the moment came to recognize same-sex couples, it did so by creating a new formal means for adult couples to register their relationship and provided a new means to provide formal status for same-sex parents. And so the rules enacted in 2002 allow a child to have two mothers on the birth certificate from birth. There's no need for adoption. There's no need to persuade a judge what the best interests of the child call for. A child in Quebec may have two mothers extrajudicially, if you will, as a mere administrative matter of signing up on the birth registration. And the Quebec rules provide that a sperm donor will not be able to establish paternity and will be a total legal stranger. There's just a couple of things to observe about those rules I mentioned. They continue to follow the formal approach. One is either a parent or not a parent. There's no reference for step-parents. There's no reference towards people who act towards parents. A child on the legislative scheme can have two parents at most. And it's still a further sign of the legislature's ongoing comfort with taking formal family status as the mechanism. Some rules apply differently based on whether the child's parents got married or civilly united, or whether they're just living together. That one's really interesting because some of the sociological research on lesbian couples says that many of them reject marriage for political reasons. They don't see marriage or unmarriage as being sort of indicators of commitment. But Quebec's rules treat married lesbian couples differently from unmarried lesbian couples. So we have this carefully considered legislative program that seems, despite, if you like, its sort of radical substance, in form and origin, it feels fairly consistent with how the civil law has traditionally operated. So that's the second piece I promised you. Now we turn the third bit is the ways in which judges have sort of gone beyond those legislative reforms. Judges haven't held themselves bound by the rules enacted in 2002. So they have recognized the fact of mothering by a second woman even when parental status wasn't present. So there have been two judgments from the Court of Appeal which have required a legal mother, a sole legal mother, to share custody with her former partner over and against her protests. These are not just settled, negotiated arrangements. The Court of Appeal has imposed shared custody over the objections of the child's sole legal parent. And the court has recognized the sort of fact that in the past this former family unit functioned like a family. And of course the cases are addressed in more detail in the paper, but let me just tell you briefly about the two cases. One was decided by the Quebec Court of Appeal in 2007, and one was decided by the Court of Appeal in 2010. In the paper, I call the 2007 case the adoption case. These women lived together for 14 years. During their relationship, they adopted two children together at different points. And because of their understanding of domestic law, and probably because of constraints in the foreign country where the girls were coming from, they weren't able to adopt together as a couple. So one of the two women adopted both children. So the children found themselves with one adoptive parent, and they happened to live with their mother's partner. And for a while, both women were raising the girls together. The girls were referred to the two women as Maman F and Maman G, based on the first names of the two women. And the two women eventually split up. And at the time they broke up, it was 10 years after the first adoption had taken place. So the 10-year-old had spent her life with the two women in her household, and it was 5 years after the second girl had been adopted. And for a little time after the breakup, they continued to share custody on a 50-50 basis, more or less. And then eventually, the non-adoptive mother, the one whom Quebec law would characterize as a total legal stranger, sought to have her maternal status recognized. She sought a declaration of parentage, and the courts refused that. And then, undeterred, if you will, she returned to court and sought an order saying she had a right to shared custody, and the court granted that. And the court relied on the children's best interests as its driving factor, in particular the fact that the girls had articulated a preference that the law should recognize both their mothers on equal footing. That's the 2007 adoptive case. And the second case in 2010 I call the birth mother case. Here again you have two women living together. One became pregnant without the other's knowledge or consent, or this was not a shared arrangement. So the one becomes pregnant, gives birth to a child, and the two women stay together for 2.5 years after the child's birth. And at various points during this time, the woman who had not given birth to the child asked the other to take legal steps to recognize her parental status, and the birth mother refused. And eventually this couple breaks up, and the non-birth mother, again a legal stranger in the eyes of the law, applies to court and is granted an order of shared custody on the basis that the child had bonded to both women and the child's best interests called for that. And strikingly, if you read carefully the judgments, the judges sort of take up the language from the child welfare expert reports at issue. The judges refer to both women as both mothers. The judges say the child has two mothers. And that's very striking because what I said earlier is the Quebec family law is all about this dichotomy between parental status and people who are third parties or legal strangers. And by the time you start calling someone a mother in the Quebec context, it really feels like you've already decided I'm going to recognize some of the legal attributes of parentage on her part. In one of the cases, the Court of Appeal says, well, this child may have one mother-in-law, but he has two mothers in fact. And that's a very striking sort of thing for a civil law judge to say. Now here I need to register a little caveat that, of course, shared custody is not the same as parental status. In a number of ways, it's less. It's not permanent. The effects of a custody order can be varied down the road. In any case, a custody order ceases to have its effects once the child reaches majority. There are no kinship implications. The child doesn't gain a second set of grandparents, for example, through an order sharing custody. And should it ever arise, there are no implications in the law of intestate successions. So it's not the same thing. The courts didn't adopt these children into the second mother's family. Shared custody is nevertheless very substantial. And in the Quebec context, it's certainly unusual that a legal parent would be required to share custody on an equal basis with someone whom no legal bond connects to the child. And just before we proceed, I want to highlight the differences between the two cases, because if they're shared, if the two cases seem similar through judges acknowledging two mothers and through judges' reference to best interests of children, it does need to be underscored that in the first case, the two women had intended to adopt children together. So in a sense, you can see a court sort of retrospectively rectifying something that didn't happen right at the time. But the second case, the birth mother really thought about it, knew her legal options, and decided not to share parental status with her partner. And there was no shared plan that those two women in the 2010 case would become parents together. So far, we have legislated means to recognize a second woman as a child's parent, and then we have judicial innovation, if you will, where judges are reaching a similar outcome even though those means were not deployed. And so we move to the two major arguments, the comparative law one, and I'll be sort of briefish with it. What's the comparative law argument in the paper, and why does it matter? So I said earlier that the civil law idea is that the legislature is the one which changes the law. But of course, it's not easy getting a legislature to sort of kick into action, to get the political capital invested to really reform family law. So it's natural that in some civil law jurisdictions, people might attempt to achieve their outcomes through judicial means. But the civil law also has a sort of strong scholarly tradition of fiercely criticizing judicial innovation and also rejecting ideas which people detect, where they detect a sort of whiff of common law influence. There's a sense that the civil law has an integrity, it has an impurity, a sort of purity to it, and so aliens are sort of rigorously rejected by at least a strong strand of civilian scholars. So it's actually there are stakes involved in whether a particular idea can be connected, can be viewed as internal to the tradition, or viewed as some kind of illegal intrusion. And so my suggestion in the paper, and it's set out in more detail, is that these developments, at first blush, do look like a kind of common law thing in the sense of judicial innovation. The line the judges say that the child has one mother-in-law and two in fact, that to me feels a much more common law approach to sense that we're sort of drawing the law out of the facts rather than having the rules imposed from above. But I suggest in the paper that we can read these judgments as reconcilable with the civil law tradition. And then I suggest that progressive scholars should engage in the comparative law characterizations of the civil law tradition that would allow them to diffuse criticisms that those moves are illegitimate. So that's set out in more detail in the paper, and if you find it interesting, we could return to talk about it further. But in general, there's a sense, I think the traditional accounts of the civil law understate the scope which there always is for some kind of judicial flexibility, the scope to which there always are going to be some unwritten principles, and of which even an ostensibly exhaustive written civil code will necessarily be supplemented by unwritten principles such as ideas of equity and fairness. So that we can return to, but in a nutshell, I think these judgments can, in fact, be located within the civil law tradition. And we move now to what I call the political argument, or another way of raising it is how do we theorize the limits on the judicial role? What are the rightful limits to judicial creativity? Now, it's always a bit risky to sort of weigh in and announce that a judgment is well decided or is correctly decided. But it seems to me the two judgments I talked about basically probably are rightly decided to the extent that that means something. And in gay and lesbian literature, it's certainly very unattractive to see biological parents playing the card of their legal parental status to sort of evacuate the fact they used to share a life with someone who is not attached to the child. So there are sadly a number of these cases, and they're not very happy reading. But I do think it's worth thinking about the limits for judges to be recognizing families where the legal means available weren't actually used, particularly once legislative reform has already taken place. So I want to suggest that functional recognition of family does have limits, that it's not always the case that sort of recognizing more family ties is necessarily better than having fewer. Where there are legal channels for recognizing two women as a child's parents, I think we do need to take seriously a choice made not to deploy those channels in given circumstances. What I said earlier, we could think of as negative space. And there are a couple of reasons, a couple of lines of reasoning that support this proposal. One, some people are very sympathetic to the idea that law should recognize an autonomy on the part of a child's birth mother to parent that child singly or alone. And indeed, the Civil Code's reforms from 2002 state very clearly, in the little chapter on children born of assisted procreation, it stated that those rules are open to two spouses or to a person alone. So there's actually a legislative basis. The judges had been put on notice that one option under Quebec civil law is that a person alone may have a child and be that child's sole parent. So it's not, and also we can think of other examples more familiar to us. Individuals can already adopt alone. People can have blended families with the option for a step-parent to adopt the child, but if they choose not to have the step-parent adopt, presumably some legal effects flow from that. To carry on this line a little further, there's feminist family law scholarship on shared parenting after the breakdown of an adult relationship, and I think it's relevant here. I need to acknowledge much of that work was developed in the context of opposite-sex relationships, and much of it is infused with concern about gender power dynamics. But some of the things said, I think, do apply even to two women who have broken up. Susan Boyd has written about the constraints that a custodial parent may experience. Say if there's a custodial parent and someone else having right of access, and the custodial parent is not allowed to move with the child without giving notice to the court that she intends to do so, and the access parent then has an opportunity to sort of try to reopen the custody issue. There's ongoing contact where two people are sharing parenting, whether it's about logistics or about the larger issues. And so in these two cases, the Quebec Court of Appeal essentially imposed what Mavis McLean in the UK calls parenting after partnering on both women. So there are limits on the legal mother's ability to move on and reconstruct her life. And I want to emphasize again that in order sharing custody between a legal parent and someone who has no legal bond to the child is significant, particularly when done over the objections of the legal parent. It feels to me like the courts were regarding these two broken up female couples as if both were the legal parents of the child already, as if they saw a mother and father of a child disputing in front of them. And here it's perhaps relevant, the Quebec law is sort of leaning towards a presumption that shared parenting and shared time are the appropriate outcomes where a child's parents break up. This next little bit, where I proceed a little further, might feel a little bit paranoid to you. This is where I read the judgments and I sort of say, what are the implications in them that we could picture being pushed further in the not-so-distant future? And it seems to me that once judges are prepared to recognize forms of family that reach beyond the legislative framework in front of them, once they're prepared to say, well, this is a situation in law, I'm going to recognize the situation in fact, it seems to me we have no guarantee that they would only recognize a second mother in those circumstances. And it seems to me that they might one day decide, well, the legislature's assisted reproduction scheme contemplates two mothers and a sperm donor who's a legal stranger, but this sperm donor has acted such that I think in fact he's a father to the child and I'm going to give him a right of access, or him perhaps some kind of custody interest. So I raise the question, could we imagine that the court would say a few years down the road, this child has two mothers in law, but in fact, he also has a father. And the literature on lesbian families shows that it's a very complicated distinction between donor and dad. So sperm donors may be known to the family and involved in the child's life, but the women may intend that they not have legal rights and responsibilities. And here we might think about judges. Judges, are of course a mixed bag, some very progressive and open, others relatively conservative. So if one thinks that judges may have a sort of bias or some sort of resistance to the idea that children may not need or have a father, then one might be even more leery about the idea of courts recognizing parents above and beyond the legislated contours. So it seems to me that equality-seeking scholars actually need to tackle these issues and acknowledge that they're quite deeply divisive. Empirical research done in the States by Kimberly Richmond about the question of the relative weights of formal family status versus functioning found that, perhaps not surprisingly, people tend to give opinions that correspond to their own exact situation. So if you are recognized by a formal bond to your child, you will think that that's the appropriate basis for recognition. If you have no formal parental status, you will think that functional regulation is the way to go. But if there are some senses of legitimate limits on judges' power to expand legislated forms of family, we need some sort of theory. We need to be able to explain what might those limits be, and how do we square that respect for legislative choices with the attention appropriately granted to the idea of children's best interests. But I do worry a little bit that now that judges have a couple of new templates in their minds, that same-sex couples can be married, same-sex couples can both be parents, that they may kind of grind the facts in front of them through those templates. So they may sort of assume that those are the main forms of queer family life today. So these are difficult issues. And in places where legislatures haven't done anything, obviously important work for judges remains. But where legislative reform has been made, draft legislation has been introduced in BC, there's been some reform in the United Kingdom, there have been some measures in other provinces. I do think we need to think about the relative weight of change in one form versus another. We need to find a way to articulate how best interests of children is to be reconciled with space for differing legislative choices about the families to be recognized. So now I'm interested to hear what thoughts you might have.